Hello, everyone. My name is Larry Pino. I am the founding partner of a law firm, Pino Nicholson. We specialize in commercial law. About half of it is litigation, and the other half is really in the transactional side, including a great deal of securities work. We've been involved in Central Florida at this point and have been actively practicing for about 30 to 35 years. So I am delighted to be on the call with you and delighted that you're joining me. We're going to go through an awful lot of information, so I hope you've got your notes handy. And as we go through the slide presentation, feel free to take any notes down that you'd like. Depending upon the amount of time available in what will probably be about a 30 to 40-minute presentation, I'll see if there's any time available for questions. But if there is not any time after that, by all means, feel free to contact the office. I'll give you some contact information, and you can either send in questions at that time or just simply give us a call. Let me talk just a little bit about the whole area of raising money. As we know, there was a time, 3, 4, 5 years ago, during the Great Recession, in which nobody was raising money because nothing was being accomplished. However, based on that, the economy has obviously improved substantially, and as a result, there's lots of money-raising activity going out all over in all kinds of different projects, and I've been involved in very much a great deal of that, certainly on the security side, to some extent as a principal, but mostly as an attorney for clients that I represent across the country, and certainly in Central Florida in that regard. With that, there is a particular act which was passed, and I'm going to tell you just a little bit about that now, which was the Jobs Act. The Jobs Act came in, and you'll see that that's the very first item on the agenda that we're going to actually be discussing. The Jobs Act was passed back in 2012, specifically, by the way, for the purpose of jump-starting the economy. As you know, probably from a personal standpoint, it was really just a very slow, lethargic economy. And our president, along with Congress, wanted to do what they possibly could to be able to jumpstart the economy by getting people to go out there and raise money for different types of projects. They passed the Jobs Act that had two very distinct advantages and two very distinct sections that became relevant to that offering. One was a 506C, and the other one was known as a Regulation A+. Both of those were passed the Jobs Act, but it took actual regulations to get passed by the SEC before anybody could really do anything very effective with respect to that. The 506C was passed on October 23rd, 2013, the regs, that is, with the SEC, and then Regulation A+ was passed on June 19th of 2015. So both of those relatively new, but they have actually, at this point, really created a morphing of the way individuals and promoters and business people and investors are actually out there raising money right now. What's the relevance of that? What can be done with that? Well, by using these particular sections and by using these particular rules, you have the opportunity to be able to really focus on different types of opportunities. You'll notice in the slide, for example, you can be focused on distressed assets or different forms of real estate or portfolios of mortgages, assisted living facilities, etc. And the additional advantage is that you have flexibility with respect to how you actually raise money. So you could raise money with a direct investment in those particular assets. You can also provide an arbitrage where you provide for the funding of a particular investment class and then use that to acquire other funds or other offerings that are invested in that type and then keep the difference yourself. Of course, you have the opportunity to be able to manage either the assets or the fund and to receive management fees on that. There is both investment income, business income, and clearly the tax benefits associated with that. As I take a look at over the past number of years, certainly since the recession, I've been involved in some of these projects as an attorney, in this case, across the entire country. This one was a senior board and care, which was in the state of Washington, and it was an old facility that had been a cabin, which got renovated and converted into a senior board and care for senior housing. As you can tell, extremely pretty. This was raised with a private offering, the particular owner here took that money, did an entire remodeling, got herself licensed in the state, and now has 6 seniors that she houses here with full room and board, and of course the assistance that she provides for those seniors. There's another senior living facility. This happens to be one that I'm personally involved in. This is called Tuscan Gardens, and this particular one is the design that we intend on utilizing for our next facility, which is going to be in Palm Coast, Florida. This offer also is supported by an offering. This happens to be a 506C offering, and you're going to hear more about that in just a few minutes. This particular one, Mobile Home Parks, is a fund of funds which I handled for a client of mine who obtains investment income, funding, capital, and then invests in other funds which are invested in mobile homes. And he uses for this particular purpose a 506C offering. This one was an interesting one. It related to a fellow in the state of Oregon who did different types of historic properties. You could actually see, this is actually the picture of it, but you can see that they are he puts these old vehicles in the very front to give it that vintage appearance, if you will. And his entire business model is to take old historic properties that are in downtowns. This happens to be in a downtown of one of the smaller cities in the state of Oregon, and then to completely remodel them and convert them into office facility with a restaurant on the ground floor. Again, his use was a use of an offering to be able to fund capital acquisition, remodeling, and ultimate deployment of that particular asset. These are oil wells. I've done a number of these, particularly with the explosion in shale over these past couple years across the entire country. This one happened to be from an operator who was stationed in or was headquartered in the state of Utah, although most of the oil wells that he was involved in were actually in the state of Texas. We have another one here, which happens to be, this one is in the state of Florida, and this is a mixed-use commercial real estate, which has offices on the ground, on the top floor, and has retail on the bottom floor. And this was done by an investor who put money together with a private offering to be able to both acquire the property and then to be able to actually build new construction on the property with this particular land use. And then finally, we've got the same opportunity, which is an offering statement. This was a particular company I provided an offering statement for, which raised money for a technology which was associated with the capital markets. That is a decision analysis tool to trade and invest in the stock market, and used an offering statement to be able to raise the money for the technology development that promoted that particular business. So the purpose of showing you all of these before we actually get involved in the law itself is only to just simply suggest to you that there are lots of opportunities for the raising of money for lots of different things. And we talk more about the Jobs Act, it's going to be very clear that that's exactly what the Jobs Act is for, to be able to assist Americans to be putting together those types of capital raising activities. Let's take a look before we actually get involved again in the way it's actually done. Let me give you a very broad review of the way the law has been prior to the Jobs Act. We have several exemptions, and before I actually talk about exemptions, I should talk about the broader aspect of raising money. Most people understand that in order to raise money, you either have to have one of two things. You either have to have an offering statement, if you will, which is actually registered with the SEC in order to be able to go out and raise money, or you have to avail yourself of some type of exemption from that registration requirement. So there are different types of exemptions. If you don't have an exemption, then in order for you to raise money, you'd actually have to go and file with the SEC and get approved by the SEC. So what we had up to the Jobs Act were different types of exemptions which individuals actually used. The first one, an accredited investor exemption, was an exemption that was offered under Section 4 or 5 of the Securities Act. You weren't allowed to advertise, but you were allowed to use it for accredited investors up to an amount of $5 million. With the Jobs Act, by the way, there's really very little reason to use it, but I mention it just because you might have heard about it and for the purpose of completeness as far as this presentation is concerned. We also had something else which was called an intra-state offering. That is, if everything you did was in one state, you weren't involved in any other state, you could use this particular Section 3A11 exemption to be able to raise money for that particular offering in just one state. Again, not a lot of reason to use it after the Jobs Act, but it is available for individuals who would want to use it. The third that you heard people doing was a Regulation D. It's a 504, and that was being used primarily for those individuals who wanted to raise up to a $1 million amount in a 12-month period of time. It was an exemption. It was a Rule 504 Regulation D exemption. The problem with it was that it was not exempt from state blue sky. And that was a real concern because while it's exempt on a federal level, it's not necessarily exempt on a state level. And quite candidly, other than having come across individuals who have used Rule 504 exempt offerings, I've never actually done one, and I've never seen it as being a good idea to do one. I would much rather have done a 505 for somebody or a 506B for one of my clients. The Regulation 505 is also one that can be used, but when it comes to the fact that it's limited to $5 million, most of the time, any client who comes to me, I usually end up just simply bumping into a 506B offering instead. So let me just mention a little bit about 506B, which you see on the bottom of that screen, because it's going to become relevant to our discussion of the Jobs Act first component, the Rule 506C offering under the Jobs Act. 506B was what was used probably most principally by investors who wanted to put together a capital raising effort prior to the Jobs Act. And what it said is that you had an opportunity to raise an unlimited amount of money, so it wasn't $5 million or $10 million, it could be $50 million. And as long as you did not solicit publicly, you were allowed to raise money from any number of accredited investors, an unlimited amount, and up to 35 what were known as sophisticated investors. Now I'm going to talk about what accredited means in just a minute, but here's what I want you to recognize about a 506B. With a 506B, you have the opportunity to put together a substantial amount. As a matter of fact, several of the ones that I made mention to you, that, for example, historic properties in Oregon, that was a 506B. The Caring Cabin, that cabin that I mentioned to you, that was a 506B. In other words, they had the opportunity to raise money from an unlimited number of accredited investors and up to 35 non-accredited, although sophisticated investors, but they were not allowed to publicly solicit for those individuals. What they had to have was a relationship with them that came not from this offering, but came from something else. They could have been customers, they could have been vendors, they could have been friends and family. They could have been country club members. They could have been involved in working out together at the same gym. They just could have had a relationship that did not necessarily come from this particular investment, if you will. Used very often, the advantage that the 506B had is that it was exempt from state blue sky, which means that not only was it exempt from a federal level, but it was also exempt from the state level. Now, that was the primary workhorse for capital raising effort and had been for some period of time. Now, with that comes along a different, completely different one, which is the 506C, which was really the first major advantage that came out of the Jobs Act. Regulation D, 506C, addressed the fact that there is a real disadvantage to a 506B. The disadvantage is because you have to have a relationship and because you cannot publicly solicit, you really have your hands tied behind your back. You are only as good as the number of people that are in your, we used to say in the old days, Rolodex, that are in your contacts. So as a result of that, when you finish with your friends and your family and your members and your neighbors and the people that you know on an ongoing basis, you have nobody else that you can raise money with. Now, that's okay if you're raising a small amount of money, but it's not really the best opportunity to be able to go out there and make sure that you have the money that you need to be able to do projects. So 506C came along and said, you know what we're going to allow you to do? We will allow you to publicly solicit. However, in the public solicitation process, you are only going to be able to publicly solicit if those individuals that you solicit are accredited investors. Now, first of all, what does public solicitation mean? Public solicitation means you can market, you can advertise, you can do newspaper advertisements, you can send out direct mail, you can do a seminar, an event. You know, there's events, for example, that are done at steak restaurants. You invite people in for a lunch or a dinner and explain this investment opportunity to them. You can do all of those kinds of things to raise money, and you can do it with the blessing of the federal government, with the SEC. However, they say in exchange for that, here's what we're going to require from you, a promoter, investor, business person. We're going to require that you only talk to individuals who are probably accredited investors and that you verify that they are accredited investors before you actually take their investment and deposit their investment. Now, how does that verification take place? Well, they are going to have to give you documents that would reflect the fact that they are accredited. Now, they don't have to give you the documents. They could give them to a third party like their tax preparer or their own attorney or a CPA or an investment advisor. And that individual could in turn send you a letter that says that they have examined and have determined that this individual is in fact an accredited investor. So, two things about it. For you to be able to go out and publicly market, you have to market to individuals who are accredited and that you ultimately obtain verification that they are accredited in order for you to be able to obtain the funding that you need. Now, with that, there are some major advantages. So as long as you now know that you're only dealing with accredited investors, you can now put your entire offering on a website and make them available to the public. Now, you're not going to know whether those individuals are accredited, but what you would know, for example, is that you can put on there that says this is an offering for accredited investors only, and if you are in fact accredited, identify the fact that you're accredited so that you can at least see the documents. And then when you see these documents, which are the offering documents, once you've seen that, just know that we're going to have to get proof that you're accredited before we actually obtain your investment and put your investment in this particular offering. So all of these are intended to be ways to expand how it is that you're going to be able to go out and raise money, in this particular case, with a 506C. Now, before I start closing the loop on some of these discussion points, let me just tell you what else the Jobs Act did, and that's with respect to Regulation A. Regulation A, unlike what we just discussed, which was a Regulation D offering, Regulation A does have to be filed with the SEC, but it's a streamlined process. So unlike what is known as an S1 filing, which is the full bore, when you see these public companies, they're going to file an IPO and they're going to go public and all that, they're filing an S1. This is not that same type of thing. This is called a 1A, and what this does is this sets in motion the Regulation A process. Regulation A used to be virtually worthless and could not be used to any large extent in the past. As a matter of fact, I never did Regulation A in the past, most of the time because of the fact that you were required to comply with state blue sky, as you still are with a Tier 1. However, the big advantage of a Regulation A under the Jobs Act is that it has now liberalized the process substantially. Regulation A Tier 1, which are those that do not exceed $20 million, you're going to file it. There's no limit on the amount of investors that you need. There's no restriction on the resale, whereas there is a restriction, of course, on a Reg D. That's for investment only. You don't need an audited balance sheet and so forth. However, what really becomes relevant when you take a look at Tier 2, a $50 million, up to a $50 million offering, you can do all of the same thing. You also have the opportunity to get as many accredited investors as you like, but you also have the opportunity to publicly solicit for non-accredited investors as well as accredited investors. And the only limit is that you're limited to 10% of the non-accredited assets or income. And then you can go forward. The big advantage of a Reg D Tier 2 is that once you file with the SEC and you're approved by the SEC, it's completely exempt from blue sky. Now, what are the big advantages of 506C and Regulation A plus? It's the simple fact that you can market, you can solicit. You can go out there and let the entire world know that you have this offering. And prior to the Jobs Act, you weren't able to do that. So it completely exploded open the opportunity to let other people in on your particular type of investment or your particular type of business that you want to be able to share with others so that you can get the capital you need to do what you are looking to do. More on that in just a little bit as we talk. I have talked about accredited investors for some time. Let me just make sure that it's clear to you what an accredited investor is. When we talk about an accredited investor, we're talking about one of two tests. The first test is a net worth test. What that means is that they have net asset value of $1 million, excluding their personal residence. And when I say they, it could be an individual or it could be a joint husband and wife, but they have assets of $1 million or more, but they can't count their personal residence in that. The second type of test is a net income test. What the net income says is that they have made an individual has made for the prior 2 years $200,000 a year of taxable income for the prior 2 years and believes that they are likely to make $200,000 a year this year. If we look at it jointly, the number is $300,000 a year for the past 2 years and are likely to make $300,000 a year this year. Now, it's not both of those, it's either or. So if you qualify on the net assets, then that's all you need to be accredited. If you qualify on the income side, that's all you need is on the income side to be accredited. So now going back to the 506C, remember that a 506C, you have to be accredited in order to be able to invest in a 506C investment. That's the criterion for what that means. So, for example, on your website, you would clearly indicate that this is for accredited investors only. Oh, and by the way, here's the definition of what an accredited investor actually is. On a Regulation A, the great news is that you can get as many unlimited number of accredited investors as you like, but you can also get non-accredited investors too, and you can still publicly solicit for them. The only difference is for non-accredited investors, there is a 10% limitation. So you have the law, you understand in the old days, it was primarily, I gave you all of the different ones, but at the end of the day, it was almost inevitably a 506B, which was the pack horse, if you will, of most of the offerings which are out there. Nowadays, the 506C sits hand in hand, and of course a Reg A is certainly gaining in popularity since the rules were passed in June or promulgated by the SEC in June of this year. So what are some advantages to the 506C? Well, from a marketing advantage, it's an unlimited amount of capital. You can publicly solicit. You do not need a prior relationship. You can have a dedicated website of your own. You can also include your offering in other websites. And what I mean by that is, as you know, there are a number of crowdfunding sites which are out there. Well, those crowdfunding sites, if they're done legitimately, there are some that are not, but if they're done legitimately, they represent an actual portal for accredited investment opportunities. So they're a portal that have a dozen or half a dozen or 20 different investments, all of which are 506Cs and are made available strictly to accredited investors. So not only can you take your offering and create a website of your own, but you can also take your offering and include it in other websites that are appropriate for that purpose. You have event presentations and open market solicitations. I mentioned that earlier. For example, you can do a dinner meeting and make your offering around a steak dinner or a lunch, which, by the way, is cheaper. And you could provide the opportunity to present an explanation for what your particular offering is. And most important of all, it's what I call routinizing the capital raising function. When you have most individuals out there who are raising money, very typically they're trying to do two things at one time. They're trying to handle the asset on the one side, and then they're sporadically and haphazardly trying to raise money for it on the other side. When you have a strong 506C effort, you can routinize the process, you can put a marketing program in place, you can identify lead solicitation, you can talk to those individuals and explain the offer, you can follow up with them. It becomes a routinized process. What about the advantages of a Reg A+? Same basic advantage in terms of public solicitation. The big issue is that now you're not limited to accredited investors. Now you can do non-accredited investors. So instead of the accredited investor where you have your minimum set at $25,000 investment or $50,000 investment, now you can have a much lower threshold, $5,000 investment or even $1,000 investment in order for you to be able to attract non-accredited investors. And of course, there is a strategy associated with all of that. With that exception, only thing you do need to know, of course, is that with that, you still do need to, for Reg A+, file with the SEC. So that is a certain amount of time and a certain amount of cost attached to that, which you do not have with a 506C. So with that said, let me talk a little bit about the structure. I want to go through that, and then I'll kind of wrap up all of these points as we approach the half-hour mark. The structure for doing these really entails the following. You're going to be setting up an entity, which is the company or the fund that is going to be actually raising the money. I will typically use a fund because it just makes a lot of sense to use a fund for that purpose. It's easier from an investor standpoint to identify that they're putting investment dollars in a fund which represents the depository of those investment dollars. With that, of course, you have an operating agreement for the fund. I will typically use a separate entity as a fund manager. And of course, that entity also requires an operating agreement. So it's the fund and the fund manager. So you have, at minimum, at least 2 limited liability companies associated with that. You may question why a limited liability company as opposed to a corporation. Probably a different discussion. However, lots of advantages of a limited liability company today over a corporation, not only in terms of flexibility in the way that you handle distributions and taxes and things of that nature, but also there's a strong asset protection component attached to using limited liability companies. In business, you have the typical types. You would have your website, the tech platform. And what I mean by a tech platform is that the website for your offering gives you the opportunity to be able to capture names, to be able to capture who downloaded, to be able to actually download documents. And frankly, you can take it all the way through the actual document signing process if that's what you would like to do. But certainly at very bare minimum, a website. Home office or a suite office, stationery, and cards. What about the documentation itself? On a 506C, you have what's known as a private placement memorandum, which is the actual document. That's the example that I'm showing you a picture of for Tuscan Gardens. That's what it looks like on the 506C level. You have a subscription agreement, which is the document which is signed by the investor that says, I'm going to invest $25,000, I'm going to invest $50,000, whatever it is, and I do acknowledge all these things that you told me in the private placement memorandum. The investor qualification is similar to what we talked about before. We have to know that they are, in fact, accredited. The investor qualification profile identifies that. We need to have either proof, by the way, of their accreditation or an accredited investor representation letter, which comes from a third party and identifies how they determined that this investor was actually accredited, either by the net assets or the income. Certificate of ownership, and by a certificate of ownership, what I mean is that's the piece of parchment that I actually send out to individuals. You know, I actually continue to provide parchment. In today's electronic era, most individuals don't really expect that old stock certificate that they used to get 50 years ago when they would buy General Electric or IBM or so forth. But clearly, when it comes to private investing, having that parchment, that is a certificate of ownership, provides a tremendous amount of actual PR value and solidifies that relationship between you and your investor. We provide different types of transmittal letters. Dear investor, enclosed please find. Dear investor, I'm delighted to be able to give you your quarterly distribution, and so forth and so on. So we just simply craft those things as part of sort of what we do for our clients. But we do think it's important to communicate often and to communicate as much as you possibly can to keep investors informed. There's nothing better and more satisfied than an informed investor. We also provide a memorandum of instruction that says, here are the things to do, here are the things not to do, and so forth. Once you have raised money, there is a securities management related issue. So, for example, you do have compliance. You have to make sure that these investors are accredited. You have these letters that I was describing. You have to set up the investor account. What's their capital basis? What's their investment basis? You also have to handle the accounting, because sooner or later you're going to have to be giving them a K-1 or a 1099 from a tax standpoint. And then, of course, you have your quarterly distribution. Sometimes it's a monthly distribution based upon the objectives of the capital raising entity or individual. And then, of course, there's an ultimate liquidation. If you have that historic piece of property that I was picturing and the intention was to hold it 5 years, to rent it up, and then to ultimately sell it to a REIT, then clearly there's going to be a liquidation event, what we call a liquidity event, and there are going to be distributions at that particular point. How is it different for the Reg A Plus? Not a whole lot different. You still have most of the same stuff. The only difference is it's not called a private placement memorandum, a PPM. It's called an offering circular. You don't need to have the same numbers of documents that you have before, but you do need to submit that offering circular to the SEC along with whatever that material is that you're going to be using from a marketing standpoint, and you are going to have to send that to the SEC for review. SEC will respond, and they'll respond with several letters along the way, and then once you have those letters, then you just simply respond and give them the information they need, and so forth and so on. So it's a longer process, because think about it for a second. Once you have the 506C done and you and your attorney have signed off on it, well then clearly you're ready to go. And you can start approaching your marketing, you can start approaching your initial investors. With a Reg A Plus, you have to have that approved by the SEC first before you can actually send it out. So in summary, before I just simply open up to the possibility of questions or maybe provide for contact for questions, let me just simply suggest that when we're talking about capital raising efforts, there is no reason why A good, credible business person or investor should not be able to look for capital in a way which can truly jumpstart their investment opportunities. Now, with that said, it is not fool's play. It is not something that should be done lightly, and it certainly isn't something that should be done without an attorney. There are any number of good, successful business people that were able to bootstrap themselves into a very successful business and never have to have an attorney until some issue occurred. The one area that you do not want to do that is in the securities field. You need a securities attorney from day one. And so to that extent, I would only suggest that the opportunity is there, and if there's anything at law which has given you as an investor or business person a major advantage to do that, really is the Jobs Act. Because with the Jobs Act, with 506C, that has really liberalized the ability to solicit for investors, and for Regulation A+, which also has given you the opportunity to solicit and obtain investors from the open market, you now have a route that you did not have prior to just the last couple years. So with that said, and these PowerPoints are going to be posted on our website, so you certainly will have the opportunity to be able to go there and to take a look at these PowerPoints once again and listen to this call once again. If you'd like to have personal information or schedule a personal consultation with me, I've given you my assistant, Kathy Simmons, who, by the way, is just about ready to be celebrating her 34th anniversary with me as my personal assistant, legal assistant. So just call her direct to her desk, which is 407-206-6516. We have a number of reports, and we also, on an ongoing basis, publish items and additional webinars on our website. So by all means, feel free to check Pino Nicholson Law, and you see the spelling of that as well as the URL on this slide, PinoNicholsonLaw.com. So regardless of whether I hear from you in the near future or not at all, I wish you the very, very best with respect to all of your investing activities, and I certainly hope that this broad overview of how you can raise capital, and particularly under the Jobs Act, was helpful to you. My very best. Thanks so much for being involved. Bye-bye.